Hi, my name is Oscar and I'm a scientist. Today we're talking about the layoffs and how a person that is on an H-1B visa can protect themselves and what they can do about that situation so they don't have to leave the country. We talked about the Canadian way. Canada has implemented some policies. Now we're going to talk about what USCIS is doing and what news we can bring to the table. As you know, this channel is about green cards in which you can self-petition. That means you don't have to have a job offer and you don't even need to have a lawyer. So let's start with today's video. I had this same presentation last time. I'll leave a link to the previous video, which was mainly about the Canadian way. Today we're going to talk more about the US way, or how can you stay in the US if you are laid off. Layoffs happen very frequently. We are now in a wave. 10 to 30% of the people that are affected, particularly in the tech sector, are on H-1B visas. They are immigrants that came to the US to contribute with their highly expertise in different sectors, but particularly tech is the main one. And these people, when they are laid off, they only have 60 days to find a new job. And more frequently, companies are not willing to sponsor, or they are very slow to react and they get in trouble. So I'm not going to go through the figures. You can go to this great website, layoffs.fyi, and you can understand the numbers, you can understand the situation, and you can track how layoffs are happening, or they are slowing down, or they are accelerating. But today we're going to talk about what to do if you are laid off. Particularly about, can you get an EAD card from USCIS even if you cannot file for adjustment of status. I have a previous video about this where I talk about the general alternatives you have once you are laid off. You can go and check it out. I'll leave the link right there. And to summarize those options, if you don't have an existing green card application with USCIS, what you can do is, one, of course, you can find a different employer within 60 days to get your H-1 visa transferred. You can get a job in a CAP-exempt organization because that's a slightly different type of H-1. You can go back to school under an F visa. You can create a business and get sponsored by it, but this is complex and risky, and I talk about that in the video. And you can, of course, start your EB-1A or EB-2NAW petition, which I strongly encourage, so you can be independent. You don't depend on a company. Your future in America is only about you and about your process, and you don't have to deal with HR, you don't have to deal with their lawyers and all that. What happens if you have an existing green card petition in progress? And this is what we are going to focus today in this video. You could get an EAD card, a work permit, with compelling circumstances. This is category C35 for up to 1 year with the option to renew. Right now, USCIS just issued guidance. We know that this existed since last February, but now they issue guidance. And that means there's a little bit more information on the process. But this is for people that have an I-140 approved. Okay, so imagine that you filed for a green card, you got I-140 approved, you are waiting to adjust status. This rule may give you the chance of getting an EAD card. So what is good about this? That USCIS gave us more information, so there is more clarity. What is bad about this? That this is not going to be as useful as most people think. Okay, even though there are a lot of videos out there with a thumbnail saying, rules are relaxing, this is getting easier, fast EAD card. That is not at all the reality. I'll leave links with the official information where you can read. Everything I'm telling you here is in the official websites, so you can go and check that directly. So if you want to get this EAD card, what do you need? You need to have an I-140 approved. You need to be the principal beneficiary of that I-140. So that may be on EB1 category, EB2 category, or EB3. Your visa must be a valid E3, H1B, H1B1, this should be a comma, O1, or L1. You shouldn't have an adjustment of status pending. So that means that maybe you got your I-140, but you're still waiting for your priority date to become current. Your immigrant visa is not available. Again, this is what I'm just saying. Based on the Visa Bulletin, you're in the backlog phase, so you cannot file your adjustment of status. Applicants, so you and your dependents, will have to go and provide biometrics. Of course, you are not convicted of a felony or 2 or more misdemeanors. And you will need to demonstrate, and this is the key aspect, you need to demonstrate compelling circumstances for this EAD. So let's get into that compelling circumstances, and this is the important part. You have to prove either you have serious illness and disability of you or a direct dependent, that your employer has retaliated against you based on a dispute that you have with them, that you have any other substantial harm to you. And number 4 is that there is a significant disruption to the employer. So we can go to the policy manual and understand what they define as hardship. So one thing that you can claim here if you are laid off is that you are under financial hardship because you lost your job and you need to get money in order to sustain you and your family. Job loss may be sufficient to establish financial hardship depending on the individual circumstances. For example, the loss of health insurance may rise to this level for a principal applicant and their dependents facing extended illness or requiring extensive medical treatment. So they give you some examples here. So you should provide an explanation supported by evidence such as financial records or bona fide cost estimates demonstrating the inherent financial hardship that you are facing. So USCIS generally does not consider unemployment or job loss in and of itself to be a compelling circumstance unless the principal applicant can show additional circumstances. This is important because earlier we could say, well, based on what they told us, losing the job is already one of the reasons you can file for this EAD card. Now they are telling us, well, not so fast. Job loss is not by itself a reason. You need to have something else. And they give an example. A principal applicant who has lived in the US for a considerable amount of time and has school-age children and a mortgage may face compelling circumstances if, because of this situation, the family may be forced to sell their home for a loss, pull the children out of school, relocate to the home country. And then they clarify, well, you don't have to have all of that. You don't have to have the lengthy stay in the US, the mortgage, the kids. They will judge your case on a case-by-case basis. So the more you can prove, the better your chances will be. But you see now that this is not straightforward. How do you apply for this? Well, you will file an I-765, which is the form for the EAD card, the application for employment authorization. You will submit supporting evidence, and you can check this website to know more about it. Cost is about $400 and then $85 for the biometric fee for you, and the dependents will also have to pay the biometrics. Timeline will be, I think that the timeline right now is about 6 months of median processing time, and this is from the official historic processing times that the USCIS releases. So you can request expedite processing. They may accept it or not, but now you see also that in terms of a timeline, this is a very lengthy process. If you are on an emergency situation, being laid off, you have to prove a lot of things, you have to convince them first, and then you have to go through this process for months waiting for the EAD card, okay? So warnings, an EAD card is not an immigration status, okay? So if your H-1B ran out and you get this EAD card, but you don't have an underlying visa, this EAD card will not be a status. So if you are waiting for your adjustment of status, then you will not be able to adjust status because you don't have an underlying status. EAD card is just a benefit, it's not a status. So it lets you be in the US without accruing unlawful time, but you cannot adjust status on that card. you would need to process your green card using consular processing. So if you had a pending I-140 with adjustment of status, you have to contact them and make sure they transfer that to the MVC, go to consulate processing. You will have to go abroad to do the final step because you will not be able to adjust status. During the waiting period, travel is not possible. So if you're waiting for the card for those months, you cannot go anywhere. And the card is for 1 year that you can extend, but you need to renew the EAD card as long as you need it for. If you're serious about your immigration status, avoid having to think even for a second about this EAD card under compelling circumstances and start working on your green card right now. You have two good options if you are on an H visa. It means you are highly skilled, so you can go for EB1, and I have a website, eb1greencard.info, with a lot of information. And you also have the slightly lower standard EB2 NAW, or National Interest Waiver, and you can check out my website as well. In both categories, I have online courses that teaches you how to fulfill the requirements, how to put all the documents together, so you can do this by yourself without hiring a lawyer, without spending thousands of dollars. But of course, you have to have the motivation, the time, and the energy to do this. I'll teach you how to do it, but you will need to do the job for yourself. With that being said, I hope you're not in a layoff situation. I hope you have a lot of time to react, prepare your green card petition, get your future in your own hands. And as usual, thank you for watching, for subscribing, for sharing this video, and I'll see you in the next video.